Call to order the Stark County Board of Elections special board meeting for Friday, February 21st, 9 a.m. Roll call, please.
Chairman Crucio. Here. Member Brady.
Here.
Member Klein.
Here.
Member St. John.
Here.
That is not qualified under B8A or B8B, and that he's not qualified under B9. I think that's A and B2. We're also asserting that he's precluded from the candidacy by virtue of 273314, and I don't think that's really an evidentiary issue, it's a legal issue. The statute speaks for itself, and you all will agree or disagree. But I think for purposes of evidence, again, to summarize, we're looking at 311.01 B8A, 311.01 B9. And then again, at the end of the protest, rather a miscellaneous matter, we're also asserting that Mr. Meyer does not meet certain provisions under 109.741 at secretary. And I think that's it.
It's okay. You also filed a supplement?
Yes, and the purpose of the supplement was perhaps a little bit of overkill, but to assure that the protest covers all the relevant statutory provisions. The protest was filed under 35-1305, and then upon further review of the relevant statutes, I thought it prudent to add that it's also brought under 3501.39A1 and /R2 and /R3.
Yeah, basically that statute is just a recitation of what happens to a candidacy or a petition after a protest. Right, so I mean, that's, you're just pointing out that should the protest fail, or should it be successful, then that's our duty.
Yes, I would say that's a fair summary. What I was looking at the latter code sections, that 3501.39, is it goes to this board's duties, this board's powers, and the ultimate result, assuming which way you decide.
Thank you. Mr. Rosenberg?
Yes, sir. Just briefly, Sheriff Meyer acknowledges that he does not meet the requirements of B8B. The issue here is Sheriff Meyer does meet the requirements of 311.01 B8A and B9, and that's the narrow and very straightforward issue that we believe is before the court, before the tribunal here this morning. The other statutes that are referenced are all procedural statutes as to what happens if, and therefore we think the board is capable of figuring that out depending on how it rules. But the simple issue before us today is whether or not qualifying with 311.01 and the issues are limited to B8A and the entirety of B9.
Okay, thank you. Any other issues, housekeeping that you want to take care of before we get started?
Yes, Mr. Chairman, I have filed a notice of objection with this board on Monday, and I thereafter provided it via fax, and thereafter provided hard copies to Mr. Seacrest. I presume you all have it, but if not, I have copies. Do you need that? Maybe that be the safe bet. I respectfully suggest one of the, by the way, I notice a lot of armed officers. Did the board retain officers for purposes of public safety today? Mr. Chairman? Did the board order, afraid there'd be a riot, did you order?
We did not see any suggestion to how an officer should come to this meeting. They're all, I'm sure, abide by whatever their departmental rules are based on whatever department they're with. And we've not had any order from our board to carry or not carry firearms.
I would object on behalf of my client to anyone bearing a firearm during these proceedings. Certainly no need for it. I'm presuming these officers are here to show support for the boss. That's a nice thing to do. That's fine. Rather intimidating to see a bunch of officers wearing firearms and uniforms, and perhaps that's the purpose, is to intimidate. I object and respectfully suggest the court should direct removal of all firearms from these proceedings.
Your objection is noted, and as chair, I do not feel it's well taken. So what's your next matter?
Getting to the notice of objection that's just been handed to the board, I think a threshold thing, and I'm not sure the applicable statutes don't seem directly to give this board power to remove a fellow board member. But when you look at the Secretary of State's duties, which you kind of get by proxy when you're appointed, clearly the Secretary of State has the authority to a board member. I object to the participation of Mr. St. John. He has twice voted for Mr. Meyer, and of course, both of those votes involve the same code sections that are now before this board, sufficient qualifications. He also signed a letter on Mr. Meyer's personal home stationery, joined me in voting for Mr. Meyer. This was for the first DCC appointment. Thereafter, he spoke to the repository and said something like, "It's always been my opinion he's qualified." And the next day, he spoke to the Alliance Review and said, "It's my opinion." I believe he cannot humanly be non-biased, and I believe he's predisposed, and again make a formal request for his recusal.
Thank you. Your motion or your request is noted for the record. And basically that, I think there's been a number of letters that you sent to the Secretary of State. I think there's been a response. Our duty here as individual board members is we don't have the power to tell somebody that they should be removed from this board. So I would tell you that if Mr. St. John, he submitted an affidavit. He's indicated that he can be fair and impartial, and that's a right that belongs to him. And so I would note your exception for the record, but proceed with Mr. St. John.
Asking you to note it was my primary purpose. I'm not reporting this board has the authority to order him to disqualify himself. Perhaps you do, but I couldn't find any jurisprudence on point. Probably a rather unusual circumstance. Attendant with that, however, the other part of my client's notice of objection, and it's also related to a complaint filed in the 5th District yesterday. Hand the board a copy. I have delivered this to your board offices also. I'm asking that this hearing be continued on multiple bases. Number one, awaiting either the Secretary of State or the 5th District Court of Appeals decision on the disqualification of Mr. St. John. I believe his participation taints the proceeding. Would refer both to the notice of objection and to the prior correspondence to the board regarding Mr. St. John, and the prior correspondence to the Secretary of State, and finally to a complaint filed yesterday before the 5th District Court of Appeals in case number 2014 CA0025. Having not done a complaint of prohibition in my 30-some year career, I don't know how quickly the court will act. I know it gets expedited treatment, but what expedited means to me and to you and to the court will be entirely different things. I think on that basis alone, this hearing should be continued. And additionally, this board, I believe, unlawfully denied the issuance of 2 subpoenas, denied the issuance of 1 subpoena in its entirety, and gutted the other subpoena as far as the Duke is taken. I don't think this board had authority to do that. That is also now before the court in the 5th District Court of Appeals. I would also point out to the board that my client's protest, as a matter of statute, the filing deadline is today at 4 o'clock. Now, she filed it early, but I think that's important for this board to decide whether or not to continue this hearing, because obviously if the deadline is 4 o'clock today, there's no need for the, in fact, be physically impossible for the, if somebody waited for the deadline for the actual evidentiary hearing to proceed on the date of the deadline. So I would respectfully request that my notice of objection be granted to the extent this board adjourn pending resolution by the 5th District Court of Appeals and /or by the Secretary of State. Thank you.
Thank you.
May I, like, just for the record, so we can have a good record here, I'd like to respond to Mr. Connolly's comments that he just made. First of all, as a matter of law, the mere filing of a writ does not stop the proceeding from going forward in the absence of an order, and there is no order that has been issued. Setting aside the merits of the writ or Mr. Connolly's election not to advise the Court of Appeals of what the subpoena even says, in the text of the subpoena, etc., in the absence of any court intervention, this hearing should go forward and needs to go forward. It's a very narrow issue on whether or not Mr. Meyer meets certain time and other eligibility requirements to be sheriff, and I think this board can proceed. The subpoena itself, Mr. Connolly continues to ignore the elements of the subpoena, complains that the subpoena has not been issued to compel Sheriff Meyer to be here. We all know Sheriff Meyer is here. He is sitting to my right, and therefore it is nothing but a vain act. The subpoena asks the Sheriff of Harrison County to provide, among other things, any and all correspondence received or transmitted from the Sheriff of Harrison County's office from December 1, 2012 to date. This board clearly had the discretion and the authority to modify, quash, or refuse to grant that part of the subpoena. For this board to do otherwise would have subjected the Sheriff of Harrison County to produce, among other things, confidential law enforcement documents, Homeland Security documents, school security documents, and I don't think Mr. Connolly, and I don't think any lawyer in their right mind would expect that that subpoena should be issued requiring the Sheriff of Harrison County to produce that kind of confidential information. Therefore, that is proof positive that it's within the discretion of this board to modify subpoenas, and it did so, and that was appropriate for it to do so. This hearing is a narrowly focused issue, and it needs to go forward.
Thank you. I would indicate that this matter will proceed today. The protest was filed. We timely set it for hearing with the location, time, and place. Doesn't matter that today's the last day. It's based on when the protest was filed. So we did that. We did our duty. Also, we have an inherent authority to issue subpoenas or not issue subpoenas or to modify subpoenas. And it was board action that we took with respect to the subpoena that was taken, and as well to the candidate. I would point out that I think there was a request from the candidate for a subpoena for someone, but it wasn't brought before our board. We did not send that out, I don't believe. So we take our responsibilities seriously, and would indicate that we're ready to proceed